determined that they will not take further action for economic considerations. And let me just locate that. But my concern here is that we are very concerned when we find that a public official has violated our laws. I find it disturbing that we did not make, the Office of the Public Auditor chose not to take further action on the matter. I would think that they would make every effort to make sure to protect the public's interest, to make sure that not a penny is paid to Buckingham. But it waited until now.
What?
Excuse me, let me finish. About 2 years later, and the AG has accumulated how much, the office of, I'm asking right now, why is it that we did not take action at that point, and we even came out very emphatic that we will not pursue further action on the matter when we know that our interest here is to make sure that the public auditor is to ensure that no public funds, there's no waste of public money. And we allowed the Attorney General, the case, to be closed and to allow the AG to continue to collect, to continue to be paid. And why didn't we, if we were so concerned about protecting our money, the public's interest, and we were so concerned about making sure that we don't waste any public funds, all the resources of the government are protected, why didn't we take care of it right there and then? Why did we close it and we even come out with a statement that we are not going to take further action at that point? Why now? I want to know, what is the motive? What motivates us now?
Vice? Mr. Hasselback, do you wish to respond?
Yes, I do, sir.
Please do so.
I'm trying to gather my thoughts. There were several questions asked of me. Ma'am, you asked why wasn't further action taken at the time. My question to that would be, what other further action would be contemplated? The only other further action that we could have taken at the time was to file criminal charges.
I guess that would be my question.
Your question is why we didn't...
We came out, instead we came out and said no further action is going to be taken. So why now? You mean we just woke up?
No, ma'am. All right, this was not...
I'm asking.
And I'm trying to answer, ma'am. This was not a flippant, knee-jerk reaction. If you'll see the December 13th, 2010 letter, bottom of the first page, it states, OPA has independent statutory authority to pursue criminal prosecution of these violations. However, after careful consideration, OPA has determined that the cost of prosecution to the Commonwealth taxpayers would outweigh any potential benefit in terms of enforcing the Commonwealth laws and restoring the public's trust in the government. Indeed, OPA is currently deferring to and relying upon your good judgment to impose appropriate remedial administrative sanctions.
Just so that I do not lose my thought at this point, well, from the governor's letter, if I may continue, it appears that he's not agreeing with the recommendations of the public auditor. So as the office that is going to protect the public, what further action are we supposed to do? We just leave it at that?
No, we filed criminal charges this
So why
year,
wasn't
and I'm attempting to put him in jail.
criminal charges filed at that point?
Why weren't they filed on January?
Witness, Mr. Hasselback, let's have some order in here. And likewise for the Vice Speaker, we can allow discussion or rather responses, but it's going too fast. The members can. So, please, you, Vice, you have already, I think, stated your concerns. And Mr. Hasselback, are you done addressing the concerns she raised?
Sir, I haven't been able to complete an answer to a question in about 20 minutes. I'd like to complete an answer to a question before I'm asked another one.
So let's do so, one at a time, okay?
Sir, if I could just finish the answer to that last question I was asked.
Please finish it.
Your concern, ma'am, is why the Office of the Public Auditor waited until August 3rd, 2012, to file criminal charges against Edward Buckingham, when it was clear on January 6, 2011, a year previous, that the governor wasn't going to take any efforts to remediate this question. Well, ma'am, I can only talk about what happened after February 26th of this year. We made the determination to reopen this case and file criminal charges. We did not violate any laws doing so. There's not been any expiration of any statute of limitations barring us from bringing this case. Sometimes things take time. We are an office with limited resources and limited people. It took our office almost a year to hire legal counsel because of roadblocks placed in our path to do so. My apologies if we didn't act swiftly enough. But we've acted according to law, we've acted according to our constitutional mandates, and we are doing this for the right reasons. We are not doing this for the satisfaction of a personal vendetta. This is being done because we believe there has been a violation of Commonwealth law, and we are seeking to hold those responsible accountable for it.
Thank you, Mr. Hasselback. I think Representative Tip had... before Representative Tip, may I just get some clarifications? I've been listening to everything that's been said. I think it's been made abundantly clear already.
Mr. Chairman, I'll try to clarify.
Please do.
Thank you. Just one simple question for the gentleman. The date on the to determine that you now need to further investigate after the January 6th letter from the governor disagreeing with the governor's position, and subsequently what is the specific date that OPA determined to again, I guess in someone's word, reopen the issue?
Well, sir, we keep falling into this pattern as describing the case as closed and then reopening the case as if it's some...
Reopen, what's the date?
As if it's some form... I don't have a specific date for you.
Roughly month and...
I would say roughly between March and April of this year. Because that's when I got into the office, had had enough time to get my feet wet, and began discussing other cases.
Okay, Mr. Chairman, may I proceed?
Do so.
Okay, before I do that, I'd like to ask our legal counsel to maybe pull out the constitutional Article 3, subsection 11, and so that I tie in my question to 1 CMC subsection 7847B. That's the criminal prosecution of authority versus the constitutional provision as cited by the Office of the Governor. So let me again go through what we did yesterday in asking Mr. Pai some of the process and the steps that led us or leads us to where we are now at this point, August 6th of this year, OPA filing criminal charges at the court, specifically the Superior Court. I'm going to go through some sort of timeline so that hopefully, Mr. Chairman, just for clarity, in sometime in January, and please interject if my dates are not in line with what OPA has done, and it's also stipulated in the report of investigation, August 31st, 2010. There was an issue order by the AG on track number 10-0096, and that issue order came as a result of some complaints, some concerned citizens. Something came to the office that there needs to be an investigation on the Attorney General. Are we still in line with that?
That's correct, sir. We initially received these complaints
January 10 sometime, 2010.
Yes, that seems to be about right.
Yes, and so after that, you did from say about August to sometime in December. That's almost like a 2 months period. You issued a letter to the governor on December 13, 2010, with your findings and recommendations.
That is correct, sir. Yes.
Subsequently, after that, a month later, January 6, we're going now into the next year, 2011, the governor issued a letter to OPA citing just roughly three issues or three concerns that he disagrees with the finding of your investigation, and that your investigation lacks any investigative fact-finding issues as well as some legal analysis. So the governor is disagreeing with you that you didn't do your work.
That's correct. It's January 6th.
And at the same time, in that letter, that you have all your facts and the basis of facts for even heading towards a possible criminal violations that you lack, OPA lacked that, lack any basis for finding a criminal violation. In other words, you found it in your report, in your recommendation to the governor. You said, yes, we have facts directing us to possible criminal violation. The governor wrote back and he said, no way, this is not correct. And further to that, and he also issued that you have a lack of criminal prosecution, and that's, what's that section again? Is that a constitution? Yes. Because of that statement, and now we're there on the lack of criminal prosecution, because the governor responded, instead of following the OPA recommendation, the governor responded with 3 items, and one of it is the lack of criminal prosecution authority. And if you're looking at the screen, and that's the constitutional provision that's provided forth in the letter from the governor to OPA. Are we in line with that?
Yes, sir. There's a section 4 of that January 6, 2011 letter entitled Lack of Criminal Prosecution Authority, where the governor essentially writes a legal brief and provides argument that the Office of the Public Auditor does not have any independent prosecutorial authority separate and apart from the Office of the Attorney General.
But further to that, if you look at section B of that, that's the one, right? Council, yeah. On section B, it says the public auditor has reasonable grounds to believe the governor or the Attorney General has violated federal or Commonwealth criminal law. The public auditor may use the legal counsel for the office of OPA or retain special counsel who shall serve as an assistant attorney for purposes of investigating and prosecuting if necessary on those criminal laws.
Yes, sir. That's the particular provision that you've just read. I cited in the criminal information. It's the first sentence of the criminal information. It says, the undersigned, that's me, brings this action in the name of the Commonwealth of Northern Mariana Islands pursuant to 1 CMC 7847B. Now, the governor's January 6, 2011 letter recognizes that this is the statutory provision upon which we're basing our assertion that we have prosecutorial authority. Now, he says in this letter that yes, that's what the law says, but that law is unconstitutional. I disagree. And we brought this up previously. I believe this was brought up the first time I testified before the panel. This law has never been scrutinized by our courts because, to my knowledge, this is the first time the Office of the Public Auditor has criminally charged someone under this section. Now, of course, Mr. Buckingham has brought up the constitutionality of this section in his criminal defense. I'm not going to go into the details about it, but the only body in the Commonwealth that can determine whether or not this is constitutional, we can all have our opinions, but the only body that can determine whether or not our prosecutorial authority is constitutional is the Supreme Court of the CNMI. Now, having said all of that, whether or not the authority under which I prosecuted criminal charges in this case really is irrelevant to the proceeding before this panel, because this panel is trying to determine the allegations contained in the articles of impeachment. Now, I may be, and quite frankly, sir, I'm not trying to be flip about this, but eventually this question is going to come up. Whether or not I'm authorized to bring criminal charges, that's going to come up. It's going to be litigated. I might be right. I might be wrong. We don't know until the Supreme Court says so. And that is a question that's going to be decided, but quite frankly, you have all of the evidence that I have in front of you. So if I am eventually deemed not to have that prosecutorial authority, that shouldn't stop you from looking at the evidence in front of you and deciding whether or not to believe it. That's up to you. Whether or not I'm doing something that is unconstitutional, that's for the courts to decide. I don't think I am. But again, it's really not germane to this discussion here today.
Correct, and the article is very specific. It's not dealing with this issue. So, with that, can the council? I mean, maybe you don't have to try to read the Constitution. Article 3, subsection 11 says it vests only the Attorney General with prosecutorial authority and power. I guess what it's suggesting or what it's saying is that it's only the Attorney General who can prosecute.
Well, that's the argument presented here by the governor that I don't agree with. The argument that is presented says that, well, yes, the statute empowers OPA with criminal prosecutorial authority, but the Constitution says only the AG's office can prosecute crimes. I don't agree with that. I don't think that's what the Constitution says. I think the Constitution says that the AG's office is empowered to prosecute crimes. But I don't think the Constitution says it is the exclusive body that is empowered to prosecute crimes. If you read, it says the AG shall be responsible for 1, providing legal advice to the governor and executive departments, 2, representing the Commonwealth in all legal matters, those are civil matters, and 3, prosecuting violations of Commonwealth law. It doesn't say prosecuting all violations of Commonwealth law. It doesn't say it shall have the exclusive power to prosecute violations of Commonwealth law. My interpretation of this is that, yes, the Attorney General is vested with authority to prosecute violations of Commonwealth law. But that's not exclusive. But again, ladies and gentlemen, that is something to be decided by the courts. And that is something, quite frankly, that doesn't have to do with whether or not Article 10 of the articles of impeachment has been supported. I mean, I can give you my interpretation of this. I can argue it, and you'll hear it again when this gets argued in court. But you know, we have a disagreement. Lawyers disagree all the time. Otherwise, we wouldn't get paid. There's a disagreement here as to what the Constitution says.
Mr. Chairman,
Okay, Mr.
I
Chairman.
don't want to be confused. So can the witness just stay with, you know, the language of the Constitution is very clear, and I do not want to be confused here.
Representative Tip-Tip, are you continuing?
I'm done, Mr. Chairman. I was just trying to align the dates and the concerns that the Vice Speaker has on why it took this long time for this to move forward. Thank you.
Thank you. I'd like to weigh in on the discussion. I've been listening to the concerns. Now, Mr. Hasselback, I will ask you very short yes or no questions.
Yes, sir.
To address this concern.
I would love some yes or no questions.
Thank you. The first is the concern about reopening a case after it's been completed and closed. Question: if a case is closed and confidential, does that mean that it is resolved and done completely? Yes or no?
No.
Okay. If a case is closed, can it ever be reopened?
Yes.
Okay. Mr. Hasselback, one of the other contentions is why the OPA did not just prosecute him after their investigation. Why did they submit recommendations to the governor? Why didn't you just prosecute him? And I think, can you just answer if this is correct? Because I was looking at your report to the governor, dated December 13, and it references 1 CMC 8562B. And if I go to 1 CMC 8562B, it states, if a person investigated is a department head or appointed official, and the public auditor finds that the corrective action should be taken, the public auditor shall send his or her report to the governor. Is that why you sent the report, offered recommendations versus prosecuting or filing charges?
Yes, sir. That is why we sent recommendations.
Okay. Now, subsequent to that, OPA again received complaints of other ethical violations by the Attorney General's office. Subsequent to the case being closed, was that a factor in consideration of reopening the case that was completed and closed?
Yes, sir, it was.
Mr. Chairman,
Thank you, Mr. Hasselback.
Just to follow through with a question. So, in the letter that you wrote, or the public auditor wrote to, and it was the public auditor that reopened the case, right? Is that what I'm reading to?
There was a
understand?
there was a decision made in our office. Yes, it was.
Well,
Who
made that decision? There is and we're awaiting still that letter that says Mr. Hasselback, as the chief investigator, reopened the case.
I don't believe there is a letter to that effect, ma'am.
Well, that's what we are led to understand, that we're still waiting for that. Something has to be open. But anyway, my concern right now is, and that letter, let's say that letter exists, it would outline the reasons why the case is going to be reopened, right? Isn't that what I would expect to see?
I can tell you the reasons the case was reopened.
Well,
And I think you have.
I've been
More than
attempting
one
to do that all
occasion.
morning.
No. I'm talking about that letter because you are telling me verbally we are these members, because I remember that Congressman Torres asked for that letter, and the public auditor said that he's going to provide us with that communication that says essentially that the matter, this case is reopened, because everybody understands from that, even the governor understands, because he was the receiver of that letter, understands that the matter is closed. So I am expecting to see the reasons, the reasons why this case is reopened. My other concern is the communication, the response of the governor outlines or refutes the points that were brought up. I guess the findings and the recommendations following. So it's very clear that the two agencies, the governor and the public auditor, are not agreeing. So I would imagine that if this is a very serious case, like that we will not just leave it like that. Instead, we will not just leave it alone, that we will pursue it. But instead, the public auditor says no further action is contemplated, knowing full well that the two are not agreeing. So where do we go from there? Instead, we receive a communication that says no further action is going to be taken. Matter is closed. And we know that the two are not agreeing. And these are, just reading from the recommendations, these are very serious. And the public auditor came out that based on his findings, that the AG violated our laws. Thank you. I'll yield for now.
Thank you, Vice. And I think I'm going to rule that we move on. We have stayed on one matter, not even one subject, one matter. Are there any other questions that the committee may have, other than what we have just spent an hour discussing? Representative Torres.
Thank you, Chair. George, just wanted to clear this verification. You worked for OPA in February 2012?
Yes, sir.
Present, right?
Yes, sir.
Now, you said you worked for PSS as BOA legal counsel. When was that? From what date?
I'm trying to think, sir. I worked for PSS Legal Counsel. I left there in February of 2012. I believe I began around January of 2010.
Okay, and then in the OAG as a criminal prosecutor, you start on May 2009 to what?
May 2009 until I left to take the job with the public school system. And I believe I went to the public school system in January of 2010. I'm sorry, I don't have my own resume memorized. I think those are approximate dates.
Now, before becoming an assistant AG, what is your duty before that?
Before I was an assistant attorney general, I was in private practice. I was in private practice from May of 2005 until I took the job with the AG's office, which I believe that was, summer of 2009. I believe June of 2009. It's about 4 years. And I worked with the law offices of O'Connor, Berman, Dotson, Baines here on Saipan. And prior to that, I was a student.
Okay, George, just going back to the early statement you made, that you said that you and Mr. Mike Pai have a discussion last night after, in discussing the issue here? You said that he delegated you officially on the ARA case. Am I correct?
Well, sir, I want to make sure we use the right terms here. With regards to the ARA case, there was, remember, when I discussed that before the panel, I mentioned that there was a refusal to provide information by the Attorney General and the Governor. And they refused for several reasons, some of which accused Mike Pai of bias. So in response to that, Mr. Pai recused himself, which is a legal term meaning, if you have a family involvement or something, you recuse yourself. Judges do it a lot. They step aside and they put somebody else in their place. So for the purposes of the investigation and the prosecution of the facts surrounding the sole-sourced ARA contract, Mr. Pai formally recused himself and appointed me in his stead to handle those issues. With regard to the issues before the panel today, those involving the party hosted by former Attorney General Buckingham, that was delegated to me to handle as part of my normal duties. I handle investigations and prosecutions in our office. So that was something that was given to me as part of my daily duties. There was no formal recusal and appointment as acting anything for this set of facts.
That means that you automatically been attached to that case on the AG, right?
Yes, sir. The case that we're talking about today. That was a work assignment. That was
no documentation of authorization.
I don't believe there's an official letter saying George handle this case. It's just it was assigned to me.
Well, going back to the ARA issue.
Yes, sir.
Is that in writing too?
The recusal from investigation and prosecution of that case, the official recusal, which is a level of magnitude higher than just a case assignment. This isn't a delegation of a duty. This is an official recusal. Yes, that's in writing.
In writing. I asked the OPA yesterday to provide us with that document. We're waiting for that.
I'll make sure you get it today, sir.
Okay. Yeah, that's it. Thank you.
Thank you. I just want to remind the members it is now 12:30. We do have witnesses that are going to be coming in at 1 o'clock to please clarify and maybe we wrap it up now. Go ahead, Vice.
Yes, Mr. Chairman, I'd like to touch now on the letter from the office of U.S. Office of Special Counsel. The presentation that was
privilege. Can we ask the Vice Speaker to please speak directly to the? I can't hear.
With regards to the letter that was sent by Ms. Liverpool from the U.S. Office of Special Counsel, I just would like to note that in her conclusion, or towards the end of the letter, she said that the evidence suggests that Mr. Buckingham violated. She did not say that Mr. Buckingham violated. It says suggests.
Can you?
And then she further said,
Vice?
let me read the whole sentence.
Yeah, Vice, can you point us, please?
I'm
Please,
sorry, I'm
polite.
using the letter.
Vice, please allow me just to ask a question to clarify. Can you please point us to the paragraph and maybe which sentence you're referring
It's
to?
towards the end of that letter.
Is it the
In fact,
last
it's
paragraph?
The last paragraph, second to the last paragraph.
Thank you.
Based on the foregoing, the evidence suggests that Mr. Buckingham violated the HAT Act
by using the authority of his office to support a partisan political candidate. However, we are closing this matter without further action. So I just want to make sure that we all understand what that letter is all about.
Thank you, Vice, for so noted.
Sir, may I say something about the wording of that letter that the Vice Chair pointed out?
Do you have the document in front of you?
I've read it. I'm not going to specifically refer to anything other in that letter other than the term suggests. I'd like to clarify for the panel what that means when someone says in a criminal investigation, suggests.
For
Mr. Chair, I'll object to that.
we have some members. The chair will rule. I would like to understand what that legal term means. So please go ahead.
This the letter written was written pursuant to was written pursuant to an investigation, or purportedly written pursuant to an investigation of the U.S. Office of Special Counsel. It's very similar to the report of investigation that this committee has reviewed from the Department of Interior Inspector General. You'll see that the same term is used in the OIG report, where it says our investigation collected evidence suggesting that the contract to IPA violated multiple CNMI ethics rules. That term suggests is used. It's used in both places and used in the same way. Now please keep in mind that the only body that can say definitively someone has broken the law is a court. When an investigator or an investigative body writes and compiles a report, they cannot say Mr. Smith has broken the law. They can say the evidence suggests Mr. Smith has broken the law. The use of the term suggests does not mean that that investigative body disbelieves or is equivocal about their belief that someone has broken the law. I can speak directly to the Interior report. That agent believes that there is sufficient admissible evidence to prove beyond a reasonable doubt laws were broken. I can't speak directly towards the special counsel letter because I don't know the people involved, but the use of that term suggests does not mean they are weak on their conclusion. It just means that they cannot definitively say someone broke the law. That is the province of the courts.
So,
Thank you for that clarification. I also wanted to pose the same question to our legal counsel, just so we have more, we don't have, like they say, legal opinions are like parts of your body. Everybody has one. So
You don't have to go any further, sir. I know what you're talking about.
would you like to give us some clarification, counsel?
Chairman, I don't really think it needs to be further clarified. I would only offer that Mr. Hasselback is correct. In addition, however, the entirety of the paragraph I think should be considered, not just the one particular verb suggests. The next sentence is, we have advised Mr. Buckingham that should he again engage in Hatch Act prohibited activity while employed in a Hatch Act covered position, we would consider such activity to be a knowing and willful violation of the law that could result in his removal from his employment. So when they say again engage, that underscores that suggests doesn't mean we think it might have happened. It actually underscores what Mr. Hasselback was saying. They're politely saying he did violate the law, but we're respectfully acknowledging our role is not the court. So when they say again engage, they pretty much make that clear.
Thank you, counsel. Any further questions for Mr. Hasselback?
I do have a problem. Mr. Hasselback mentioned earlier that he said nobody except the court can definitively say that somebody violates the law.
Well, going back to the report and recommendation of on that ethics investigation conducted by PAO very definitively didn't say suggest, it says concludes that the AG's action violated criminal prohibition. So now I'm beginning to get confused. You know? So let's make it clear which one says what. Right now, it's based on the findings of the report, and I'm quoting, OPA concludes that the AG's action violated criminal prohibitions of both the Commonwealth Ethics Code. And I just want to make sure that I understand, because you are saying one thing and I'm saying something else here, Mr. Hasselback. And also, I am not... our legal counsel is saying something, is agreeing with the witness, but I'm still not sure. If they're so sure that Mr. Buckingham violated the Hatch Act, why didn't they say that they're going to pursue the case?
You would have to ask them that, ma'am. I don't know.
Mr. Please let me allow you to be recognized.
My apologies, sir.
You may proceed.
I don't know. I was not involved in the decision-making process of the the U.S. Office of Special Counsel. I don't know why they didn't prosecute the case. Allow me to address the wording of the December 13th, 2010 letter. It may have been a conclusory statement. However, again, I've told you on multiple occasions what I believe, what I have evidence to support, but again, that ultimate decision of whether or not somebody has broken the law in a criminal context is left up to the courts.
Thank you for responding, Mr. Hasselback. Are there any other type of questions for Mr. Hasselback? I think we won't have lunch if we...
Mr. Chairman.
Vice.
I would like to suggest at this point that we break for lunch, and there are other concerns, but because we are very hungry right now and the members don't need to sit in this chamber and not getting their lunch, let's break and we'll come back.
For now, Mr. Hasselback, if there are no further questions from the members, you are hereby dismissed. Again, maybe subject to being asked to come back.
Yes, sir.
We will give you reasonable notice.
I have, the Sergeant-at-Arms has my number.
Oh, one more thing, Mr. Hasselback. There are some documents you offered to provide to this committee.
I am aware that the committee has asked, specifically Representative Torres,
Right.
has asked me for a copy of the letter from Mr. Pai recusing himself in the investigation of the ARA matter and appointing me in his stead. I will provide that. I know Representative Ogamoro has also asked for me to determine whether or not there was any specific written document that memorialized our decision to re-examine the facts that were brought before the panel today.
Oh.
If I'm able to find that, if it does exist, I will provide that as well.
Yes, I just want to make sure that...
Oh, just before, I know you're going to clarify, but just so I don't forget, any documents you're going to be submitting to this body, can you please submit it to Ms. Shar?
Yes, sir.
Vice, I'm sorry, go ahead.
Yeah, thank you. My request was to submit a document that would say that the matter has been reopened and for what reasons.
If such a document exists, ma'am, I will make sure you get a copy.
Thank you, Mr. Hasselback. With that, you are hereby dismissed. Thank you very much,
Thank you, sir.
and have a nice day.
Thank you.
Shar, members, it's almost 1 o'clock. We will have witnesses coming in. Perhaps we will break until 2 o'clock. And Shar, can we have a note posted on the door that says that witnesses shall return or that we will start our afternoon 1 o'clock session at 2 instead, and on at least the front door. Okay, members, with that, we'll break for lunch until 2 o'clock. Thank you.